You've got that.
It says it's not.
That must be everything.
Court rise, if able.
So we are reassembled. I'm very sorry about that. I'm sorry in particular to you, Mr. Bewley, for interrupting your submissions like that. The gain is that it's all working.
Great.
Right.
So I'll just, you have to find your papers. So the page that I think I had asked you to turn up, or was just about to ask you to turn up, was 227 in the supplementary version.
You had, yes.
If you just go back to that. This is a clause which we understand to be the standard clause that was offered to eventually agreed with the various landowners who were affected persons for the purposes of the order. And I mean, before we look at it in any detail, on one level, this will look like, for those who do this kind of work regularly in a compulsory purchase context, might look like a relatively anodyne or familiar clause, because in a pure compulsory purchase context, of course, to have something which says you've compromised your property right, so you should withdraw your objections, is unproblematic, what I'm going to come back to. But what we need to think about its effect is in the context of this application, or these applications, I should say, for development consent orders, which of course went far wider in their effect and raised planning issues way beyond the implications for any one parcel of land of an affected person. Very different from the Fulham case, for example, which I'll come to in a minute. And so the effect of this clause on its face is clear. The grantor, that's the landowner, shall not make a representation regarding, and then it's the orders, we don't need to distinguish between them as we already said, brackets, and shall forthwith withdraw any representation made prior to the date of this agreement, and forthwith provide the grantee with a copy of the withdrawal. Nor any other permission associated with the orders. And then it goes on to say, in fact, that they have to assist the grantee to obtain planning permissions for good measure. So the clear effect of that is that a person who signs this agreement, whether or not they had to do so before, but certainly once they sign this agreement, is required to withdraw any, not just their compulsory purchase related objection, but any planning objection they might have. And that is so regardless of whether that objection relates to their own parcel of land or some wider community impact or some other part of the scheme, regardless of whether their objection is essentially a commercial one or is related to some wider environmental impact, and so on. There is no exception. There is no exception. And my basic submission is, even if, which I'm unsure about, but that's, I don't think you need to worry about it, even if this is now orthodox, it is not legitimate. And the reason is simple enough. It's that it has a tendency to cause the suppression of evidence on matters going to the public interest. Now, we're going to need to go to the Fulham case in a minute. I'll take you to it in just a sec. But just before we do that, just to kind of lay out the territory, as it were. First of all, let's just think for a moment about the wider non-planning context. Well, so outside of planning altogether, criminal proceedings, well, it's pretty obvious that if you enter into a clause of that kind which relates to the provision of evidence at a criminal trial, that's not going to be legitimate. It's going to be fundamentally problematic and contrary to justice. I don't think that's controversial, but
Are we perverting the cause of justice?
will be perverting the course of justice. Correct. I'm not a criminal lawyer, so I don't know what the provision is that that person would be prosecuted under, but I don't understand that to be controversial. It's going to be fundamentally problematic.
Right, well, we don't need to be
And
concerned
you don't
with
think
that.
you need to. The general point is the point, as it were. What about civil proceedings? Well, same. Of course, a party to civil proceedings may compromise their private interests. So if I've got a claim against X for £10,000, I can decide not to give evidence on the basis I'll be paid £8,000 or whatever it is. That's fine. That's me compromising my private interest. But if someone else is going to give evidence and they are dissuaded or deterred or bribed, likely not to give that evidence, then again, I don't think this is controversial. It's just saying it in the territory.
Well, do you say this was a bribe?
Well, the word bribe is a pejorative one, and we don't need. My answer is I don't think we need to worry about that.
Various, let's say, pejorative adjectives have been used.
Yeah, I mean, look, it's a feature of the paper. It's a feature of the way representation was made, frankly, on both sides. That there's quite a lot of, put it like this, excitement.
Well, how would you characterise this on reflection, Mr. Booth?
Well, the word incentive, which is a word which, after all, appears in the SBR's own documents, is a more neutral or less loaded term. And by the way, I'm not saying it wasn't a bribe, but I'm saying you don't need to worry about that effectively.
No, but we're interested to know how you would put it to
But
this court.
it can be. It's an incentive.
Yeah.
And part and parcel of what is being incentivised, and frankly, whether this was the intention or not doesn't matter. It's a financial incentive not to give the relevant evidence or make the relevant objection. And I was just going to, again, I'm sort of stuck in the foothills, it may be, but so criminal proceedings, civil proceedings, public inquiries other than planning, let's say, COVID inquiry, Grenfell inquiry, that sort of thing. I'm conscious my Lord Justice Dingemans probably knows a lot more about public inquiries than I do. But again, I would say at least outside some special context, it's again obvious. If a witness or a person who's got something to say is induced not to make the representation or give the evidence that they would otherwise give.
Well, you've used the word, I don't want to be pedantic in holding you to language, but you've used the word inducement, I think.
Inducement.
Or induce.
Yeah. Part and parcel of the... If you think about it So, I mean, just think about it in an even more basic way on that. I mean, this is a contract.
Mm.
But part of the consideration, indeed, most of the consideration for the contract on the part of the grantor is the payment of money. Part of the consideration on the part of the grantee, I hope I've got it the right way around,
Yeah.
is getting them to sign up to the various clauses. And one of the clauses is the non-objection clause.
The other way around, isn't it? 'Cause
Yes,
the
I
grantor
have
is the
a horrible feeling. Well, in the clause, the grantor shall not make a representation. So that's the person granting the right. The grantee is SPR effectively. I think I've got that the right way around, but I always get terribly muddled about things like that. So
Yes, the grant is going in that direction.
that's the way it's going. But I always find those terms, I make no bones about
But
it.
anyway,
Confusing, which is why I'm not a property lawyer.
You've made the submission clear.
So again, so far we haven't dealt with planning. But then come to the planning context, which is where we are. I mean, I say planning as for these purposes covering development consent as well as ordinary day-to-day planning because there can't be a difference of principle between them. Now, I accept, I'll come back to these. There are contexts in which it may be legitimate to make a payment. So it's obviously legitimate to make a payment for a property right if you're in a compulsory purpose context. It's also well known that in planning, it may be legitimate for a developer to make a payment, for example, on a Section 106 agreement. I know my Lord Justice Midland will know what that is.
A planning agreement.
A planning agreement, let's call it.
But again, I think you can assume that we all.
But the idea there is you make the payment. Let's say the issue is non-provision of affordable housing. That's potentially a planning objection to the proposal.
Mm.
The payment is made to the local authority ordinarily with the purpose that it will be used to make up for that by providing affordable housing somewhere else. Yeah. So the planning objection, the payment relates to the planning objection. To meet the planning objection, and there are lots and lots of examples of clients and so forth. Delay point. But if, on the other hand, a payment is made to an objector, or indeed a local authority, let's say it's an objector, you have a serious objection to this planning application based on, let's say, public interest grounds relating to the environment. I will, however, pay you £100,000. Please withdraw your objection. You're not required. There's no mechanism, and with a private person, I'm sure there could be, there's no mechanism to require that person to make good the environmental harm or anything with the payment. They just get the money, and their principle, but only, as probably most people are, only up to a point, so they think, well, 10,000, no, I'm not going to do it, but 20,000, maybe I will. You can understand why they would do that. You don't need to characterise it as a bribe, but it's contrary to the public interest.
Does it make any difference if the payment in question is clearly referable to the value of the land to be acquired, say?
Sure. So the example I'm taking, sorry to cut across, but let me. Okay. The example I'm taking is deliberately not a compulsory purpose. There's no land. Let's assume there's no land to be acquired. So just for the purpose of this part of the argument, I'm imagining an objector. They may be a local resident, but there's no question of compulsory acquisition. Okay, so it's a pure planning case, let's say.
Yeah, so pure planning, yes.
Pure planning case. And they are told, instead of here's our answer to your objection, please withdraw it, we'll give you £20,000. And so they don't make the objection they would otherwise make or give the evidence of the inquiry or local authority president.
What if it's a utility provider, for example, who is going to have to increase its infrastructure?
Because then it potentially meets the planning objection. If the payment meets the planning objection,
and that's the critical point, isn't it?
yes. If in other words one identifies something that would be a material consideration for planning purposes, and possibly as a second best, but not even perhaps, it said, well, okay, your planning objection is based on the additional costs you will face. So we'll meet those costs, no more and no less, or at least a sum that's calculated by reference to them. There may be some controversy, so they have to.
Well, is this akin to the traditional principle that planning permission may not be bought or sold?
Well, it's sort of shading into it. Yes.
Well, I sense that it is in the way that you're putting the submission.
Well, because I accept that that's one set of exceptions, but that's not. I mean, so payments can be made, as we know very clearly certainly in the Section 106 context, where the planning objection can actually be dealt with by the provisional money or money's worth. It might be the provisional land for alternative green space, something like that. And that's a potential exception. But then that's not an inducement to withdraw the objection. It's a meeting of the objection, effectively.
Can I just test whether this is any sort of workable proposition?
Yes.
Suppose you've got a house, you want to build a porch in a street. Everyone says this is going to wreck the street, and might even undermine the value of my house.
Yes.
And you offer 20,000 to all the next door neighbours. Is that permissible under your principle or not?
Well, we need to look at the Supreme Court decision in, I think it's called Taylor, isn't it? I think the answer is no, but I mean, there's some nuances about when it is and when it isn't, but just paying people off, no, or just providing an alternative benefit.
Well, that, in my Lord's example, it might be added that a view is taken as to the diminution in the value of a house.
Well, yeah, but you see, that's so the planning object. I mean, I don't want to get too bogged down in this because in a sense but it's instructive to think about it a little bit.
Yeah.
So the planning objection there is not, this is not a proper planning objection. Don't grant planning permission because it will reduce the value of the house. The planning objection is this will damage the street scene, damage the character of the area. And yeah, exactly. And that's not, none of the other houses have porches, so you're destroying the unity of the street scene or whatever it is. And actually that objection is not met by making the payment to make up to the current owners, because the public interest objection is not actually a public interest objection which relates to the present owner. It's related to the public interest in the relevant street scene.
But what if it's negotiated on that basis? What if it is actually negotiated on the basis of making up the diminution in value?
Well, again,
does that make any difference?
I mean, I don't. I think the answer is no, but I don't want to kind of, because I don't think my case, because that's not in this case.
No, but what we're doing is testing.
No, I follow that, but my point is that there is. I mean, the principle that we're talking about at the moment is that if the planning, the principle is that if the planning objection is met, so there's a material consideration which would otherwise lead to the grant of planning permission, and that can be removed or possibly mitigated, it could be a less powerful consideration, because an alternative, because by the provision of money, the problem is met.
That's understood.
So conceivably, if the money is spent on a wall at the front of the house which covers up the porch so no one can see it, that's okay, but probably not. But again, I don't want to.
No, fine. Against the background of those exchanges, it would help me at least, I think, if you were now to articulate, if you can, the essence of the unlawfulness for which you contend in these arrangements.
Yeah.
And if you can state the proposition, that will help us. And if you can then back the proposition up with authority, that would help us even more.
So, my lord, the proposition. I'm just wondering if I want to go to the authority first.
Well, do it in whichever way you.
No, sure. Can I just think about whether it's useful to give an answer now? Can I take you to the Fulham case and then come back to that question? Because the Fulham case, obviously, it's the only authority that deals with this.
Yes.
And
So fine. No, let's do
let's
that.
do that, and then we'll try. I don't want to dodge. I'm not dodging the question.
No, no, no. Of course.
So Fulham is in your first one, obviously. And
I've taken it out actually. It's
yes,
tab
wonderful. It's
19
in
and
it's tab 11.
tab
And
11.
the
Yeah.
judge placed reliance on this, and I think my learned friends do as well. So it needs to be treated with some care, and certainly the authority I'm going to spend the most time on. So if we go to tab 11, if you're in tabs, I know you said you extracted it.
Yeah, it's page 321 of the bundle.
Page 321 of the bundle. If we go to the head note first, there's quite a lot in the head note to draw out. So if the court has, all of the court has that. So Vicenza, I hope I've got that pronounced right, but I don't suppose at this distance time anyone's going to mind. Vicenza Development is a subsidiary of Cabra, so Cabra, Vicenza, same thing effectively for our purposes. And they're the freeholders, owners of Craven Cottage, the home of Fulham Club, football club. They apply for planning permission to develop the whole of the site for residential purposes. Hammersmith and Fulham Council applied for planning permission for an alternative development and then issued a CPO. So the starting point is you've got these two rival applications for planning permission. Vicenza then appeals to the Secretary of State for non-determination. There's a public inquiry to deal with both applications effectively. One's an appeal, one's an application. But at this stage. And at this stage, initially, the club, who are for our purposes the property owners, because they're the, although they're not the freehold owners, they hold the lease, they initially support the council's application. Then they enter into agreement with Vicenza Cabra and adopt the opposite position. And that's where you get the agreement which restricts them from making an objection, etc. We'll come to the detail of that a little bit more. And then importantly, in my submission to understanding what's decided in this case, they changed their mind again. So the head note recites some of the detail of the agreement, which I won't dwell on for now. Because, in fact, I think it's implicit that both applications are refused by the Secretary of State. Certainly, the refusal to confirm any of it. But then Vicenza appeal, and there's a further public inquiry. And now, Fulham Football Club changed their mind again. So Fulham Football Club started off supporting the council and opposing Cabra. Then they changed their position. Then they changed their position back again. And it's quite instructive in my submission in the head note to note this as well, that 4 lines from the bottom above the holding. Cabra rejected this proposition, and the plaintiffs applied for a declaration that the second of 6 plaintiffs, that's the club, were entitled to give such evidence as they believed to be in the interests of Fulham, i.e. the football club, I think that means. So their position is, they're taking a position, effectively a commercial position, to advance the financial interests of the club. And it's pretty clear, I suggest, it's not spelt out in words so many completely explicitly, but it's pretty clear that the context then is that Fulham Football Club are throughout, albeit maintaining different planning objections at different times and changing, flip-flopping a bit, are doing so for effectively commercial private purposes, not because they have any settled view about what should in fact happen to the site in the long term. Then the first instance judge, Mr. Justice Chadwick, then was found that there's an issue about the interpretation of the covenant. We didn't worry about that. So he also says it would be contrary to public policy to allow it to be enforced. Court of Appeal reverses him on both points. So if we then go, just briefly turn up the relevant clause. That's on 324 of the report.
Yeah.
It's covenant R, and it's quite long, so I don't need. I'm not certainly not, and we're not. You're not constrained for this case, so I don't think we need to get too bogged down in it. But for example, CD, bottom of 324, they've covenanted not to object or procure any objection to the way the current planning application is to any objection to that application or to any later application, effectively. So first question is, does that extend to the later planning application? The answer is on court of review, no, and we're not concerned with that. But then they deal with the question of the public interest point from page 331 onwards, under the heading public policy.
331.
Starts at 331, there's a heading. Again, it's quite long, so I won't, for obvious reason, I won't read all of it out. But the court tells us, don't need to read this out, there are various different strands to the argument, but if we pick it up at 332, there's no side lettering, there's a paragraph beginning the third strand. The third strand in the argument was based on the proposition that any contract which inhibits the disclosure of relevant matters to a court is contrary to public policy. Where in a planning inquiry, full disclosure is particularly important because the recommendations of the inspector will affect the community as a whole, not just the main proponents and opponents. Sorry, I should have said moreover, that sentence. In support of this proposition, we refer to Keeley and Thompson. Lord Justice Fry says, the tendency of such a bargain is that entered between the plaintiff and the defendant is obviously to pervert the course of justice. The defendants were under no obligation to appear. They certainly were under an obligation not to contract themselves out of the opportunity of appearing. And just pausing there, certainly, we'll see this in a minute, but the potential applicability of that principle is accepted here to be relevant to planning. So the court didn't say we allow the appeal from Mr. Justice Chadwick because it's got nothing to do with planning or anything like that. If it did, I would obviously be in difficulties. On the contrary, it says, we'll see it's repeated again and again, it's all about the facts of the case. So if we then go to the top of the next page, so 333 of the bundle, 296 of the report. So the submission is, the effect of the covenant, paragraph R2, if enforced, would be to prevent the plaintiffs from putting their true views as to the merits of the current planning application before the inspector. The covenant was objectionable and illegal. Furthermore, and it's quite instructive that this point reappears in the plaintiff's argument here. It tells you something about why the court reached the conclusion it did. As the first plaintiffs have now decided that the Vicenza application was not in the best interests of the club, any evidence which suggests the club still supports the application will be false and might pursued. So at the heart of Fulham Football Club's position...
It might be perjured.
Sorry?
Might be perjured.
Well, that wasn't the point I was going to make. I mean, that's there.
No,
but
but
it's the vindication of their private interest. That's why they're doing what they're doing. And that's why they tell the court...
That was the concept of perjury.
Yes. Yes.
Yeah.
But actually, it doesn't quite... I mean, if you think about the submission they're making, it doesn't quite follow. Because whether or not the thing is in the interest of the club is actually only indirectly relevant at best to whether, because after all, they're going to vacate the site. That's the whole point of all this. That whether or not it's in the interest of the club doesn't really go to the question whether it's a good planning proposition or a bad planning proposition. In other words, the stance they're taking on the planning proposals is dictated by, and they're open about this, the vindication of where they see their commercial interest to be from time to time. And effectively what they've done is they flip-flopped, as I've said. They've taken one view, then they've done a deal, taken another view, and then one might infer they've taken yet a third view at a later stage. That's not spelt out, but it's pretty implicit in my submission.
Right.
And then the court goes on. So we feel the force of these submissions, we feel bound to reject them. And then if I pick it up now further down the page, this is a critical bit, I think. 333. The principle which underlies both the law of contempt of court and the rules governing the immunity of witnesses from suit, however, is that as a matter of public policy, the court will prevent and, if necessary, punish conduct which interferes with the proper administration of justice. Now again, pause again, critical. They're absolutely accepting the applicability of that principle to planning. They're not saying that principle has no folding. And they say that's any contract which has a tendency to affect the due administration of justice, contract, public policy, see or England. Same in planning, effectively. And they go on, in any individual case, therefore, the question is, has the act impugned interfered with or will it interfere with the due administration of justice? It is not sufficient merely to pose the question, is the effect of the agreement that a party or a witness may be prevented from putting forward a particular contention in court before a tribunal? So you don't just ask, does this contract stop you giving evidence? You have to go on and ask, does that mean that it affects the administration of justice? And they then say, and now coming back to the case, it is necessary to take a broad view of the public interest and, where necessary, to seek to achieve a balance between countervailing public policy considerations. Thus, in the present case, there is the public interest in allowing business to be transacted freely and in holding commercial men bargains. Now, as I say, given what the court has, what I've already suggested is going on behind the scenes and is being made clear to the court, one can see why that public interest does weigh with the court on the facts of this case. Because, except there's a bit of reading between the lines, but the inference is what Fulham is doing is acting in advance of its own private interest and nothing else. It's not that it's got a genuine freestanding position on the planning merits apart from that. But what the principle that the court is indicating there, or is adopting there, is that you have to look at the facts of the individual case and you have to decide that question, the question posed, will it interfere with due administration of justice? And you do so by balancing out competing public interests. The public interest in seeing that the evidence can be given if it's against such other countervailing considerations as there may be. What it is absolutely not saying, in my submission, is that in all cases it's legitimate to restrain, to have a contract which restrains a party to a planning inquiry, or a witness, a party, an objector, whatever it may be, whatever the status may be.
Sorry, not saying that in all cases it's legitimate
to enter into a contract under which they are offered inducements not to give that evidence, not to give evidence or maintain objections. It's saying that recognising the potential problem, we think that on the facts of this case, this was a legitimate thing for Cabra to do. And why is that? Well, again, it's holding commercial men to their this old-fashioned phrase, commercial people to their bargains. Top of page 334 of the bundle 297 report. And lest there be any doubt about the generality of the ruling, look down well, we should probably note the next paragraph. So they make the point that there will be cases where parties can properly and legally reach agreements, future course of legal proceedings. They give some examples, but the point about that is that's all the resolution of private interest. So compulsory purchase, for example, or as I've already said, the settlement of a private claim. A person who says, X says Y to me, but if Y will pay him compensation, he's perfectly entitled not to give the evidence and not to take the case to court and take the money instead. That's because it's a purely private interest. But anyway, the paragraph I wanted to go on to, the next one, the court will consider the facts of each case. Whereas here a commercial, you see again what they thought of the facts of this case, whereas here a commercial agreement relating to land has been entered into between parties at arm's length, and one party agrees in return for a very substantial payment to support the other party's application for planning permission, we can see no rule of public policy can render such an agreement illegal or enforceable. So it doesn't mean they could be prevented from giving evidence on subpoena, and they say again, just for good measure, middle of the paragraph, we are satisfied on the facts of this case the covenanters cannot rely on any rule of public policy.
Does the second sentence permit of the qualification that you read into it, namely that it's only because Fulham were acting for their own commercial interests?
Well, you see, that's what I mean, we have to read between the lines, so I can't say, you know, I wasn't, for obvious reasons, party to this case. I'm not sure, not quite. But reading between the lines, yes, that's the inference. What they're saying is, on the fact, and you link that up with that final sentence in the paragraph that's at the top, ends at the top of this page. In the present case says the public interest in allowing business to be transacted freely and holding commercial means their bargains. And so one can see that it is authoritative for the proposition that there may be cases on a case-by-case basis on which someone who is proposing a development, perhaps as part and parcel of the acquisition of land, it's not quite a compulsory purchase case at this stage. From the changer's point of view, they don't have a CPO, but they are acquiring the land, that's part of the deal. That having agreed to dispose of the whole of your interest in your land, what you don't want then the people you're buying the land from is to, forgive me, mess around and keep changing their mind and try to get a better deal, because that undoes the bargain itself. So that's why there's a public interest on the facts of this case, which may be engaged by a land this contract to be enforced. As I say, that's to do with the facts of the case. I don't know if that's answering my last question.
No, it answered the question, thank you.
I probably answered the question and gave you some more.
But are we now ready to hear the proposition to which this leads?
Yeah. So obviously, the reason I wanted to go to this case is because obviously, in light of this case, I can't go so far as to say, which I might frankly otherwise have said, but I can't go that far.
Mm.
Look, it's only the compromise of a public, the compromise of a purely private interest, and therefore you cannot have a contract which ever have a contract.
No, but that
Which
begs the
prevents the
question.
main. Yeah, no, I follow, but that's why. Sorry, I know you want my answer, and I'm.
Right, no. Well, if you're ready to give your
Yes, I am. I think that. So, my lord, in my submission, then,
Mhm.
the position is that the starting point is that a contract under which a party agrees to withdraw a planning objection or not give evidence in the planning process is an unlawful one because, for the very reason that the court is, in this case, this earlier case, accepted, it will tend to interfere with the due administration of justice. But I accept, this is effectively what's said in paragraph 333 over to 334, there may be cases where on particular facts a justification for doing that can be found. But one would need, I mean, it may be that what this case has been taken as, or what is the practice has grown up, is to treat this case as being authoritative for a position. It's always fine. Maybe, maybe not. I don't know. But if so, that's just wrong. It's not what it says. On the contrary, the starting point should be: it's not legitimate, and one would need to identify a particular reason. In this case, gives an example of it. Why there is a public interest or legitimate interest, which meets the public interest concern. And I submit that there are some additional well, there's an additional constraint, taking the case at its absolute highest from my opponent's perspective. It does not support the proposition that you can restrain someone from making an objection which doesn't relate to their own land. As I've already said, the effect of the clause we're considering here only does have that effect. So if I own a parcel of land close to the substation, some way inland, but I've got a concern about the impact of this development on where the energy comes on shore, the dig of the trench, for example, that's completely unrelated to the land that's being acquired from me. It's completely, it would be as if Fulham Football Club were told, not only can you not maintain an objection relating to your own land, but you can't even maintain an objection relating to another aspect of the proposal down the way. So
Because
it must be related at the very least to the property right.
it must be related to the property
To the
right.
property rights being acquired.
And where do you get that from? Fulham?
Well, I get that. I mean, it's not spelled out, but it's implicit because, of course, in this case, the only land in issue is the football club's land. There isn't any other land. I mean, that's why it's so different from the present case. The land on which the development to occur is Craven Cottage. I mean, I don't know for sure that there wasn't a bit of an overlap at the edge, but basically, it's a development of the football club's land.
Suppose that the objection in the Fulham case had been to noise, traffic pollution or something of that nature.
Yes.
So suppose that it had been said, well, we don't like the look of this proposed development because of the amount of traffic that's going to be coming to all these houses that are going to be built on this patch of land instead of the football club. And it's going to result in all sorts of problems going in and around environment, pollution and so on. I just suppose that was it. Where's the distinction there between inhibiting the landowner or the leaseholder from raising that objection and raising an objection relating to, I don't know, the number of houses or how they're going to aesthetically affect the land?
My lady, I might not be capturing the nub of the thrust of the question, but I'm not sure there is a distinction specifically in relation to those. I mean,
so if it was an objection to something outside the land itself, namely the number of vehicles that are going to be clogging up the arterial road that's coming towards the development site, which side of the line does that go? Does it go your side of the line or the other side of the line?
Sorry, presumably, I mean, one of the oddities about the Fulham case is on the facts of the case, as I understand it, and I know this doesn't, history relates, it doesn't happen, but the idea is that Fulham vacate the ground to get an alternative development. But planning objections will often be relating to matters of that kind. So I'm concerned about this because I'm on such and such a parcel of land, and albeit you're not acquiring my land, it will impact me because of additional traffic and pollution and what have you.
Now, what I was postulating was
sorry,
that the people who are objecting are the people who are the vendors, if you like, of the land, right? So they're the ones who are getting the money.
Yeah.
And you say there's a distinction to be drawn between a situation where the objection relates to their own land,
yes,
and where it's a wider consideration.
yes.
For example, in this case, where the onshore work is starting, which may not be on their particular parcel of land, it may be on somebody else's. And I was just testing that proposition on the basis, well, suppose that the objectors have entered into a clause in an agreement which is going to acquire their land, so very similar to Fulham. But their objection doesn't relate to anything that's actually happening on their land, but relates to something such as the arterial traffic flow outside of it.
So when I say relates to the land, I'm not saying it has to be for a planning objection doesn't have to be development on the land.
No.
It might be development that affects the land. In other words,
So
my
where do you
objection
draw, where
arises.
do you draw the line? What I'm really sort of getting at
Yeah.
is where do you draw the line between what you say is objectionable
Yes.
because it doesn't relate to the land in the wider sense. As I understand it, what you're saying is there's a distinction to be drawn between not objecting to something that has an impact on your land
Yeah.
and not objecting to something which has a wider implication.
I am making that decision, you're right. Can I just back up a bit? Because my overriding submission is the one I made previously. My overriding submission is, if a contract which inhibits the ability of a planning objector to maintain their objection is to be legitimate, then it has to be justified by a specific public interest. And that's my main principal submission, if you like.
And yes,
And I say
and
that
I've got
follows
that.
from-
And you say that the specific public interest is that it must be related to the property rights.
No, I say, for example, in Fulham, because that wouldn't necessarily be enough. So in Fulham, the specific public interest is said to be by the court, 297, holding commercial people to their bargains. And it's a context in which you've got someone who's already flip-flopped around, as I say, and the court thought that was okay to have a contract like that.
Well, that I'm actually finding a little difficult to follow, because if the point is that you hold somebody to their commercial bargain, then that is squarely what's happened here. You've got a commercial bargain between people at arm's length.
Well, no, yeah.
So I thought that you said it doesn't support the proposition that you can stop someone from making an objection which does not relate to their own land.
Look,
It
my
must
lady,
be
we-
related to the property.
Yeah,
rights.
can I because there are two different points there, I think, so can I So your ladyship makes, if I may say so, an interesting, important point, and it goes to how we understand this judgment, and in particular what is being said on 297 of the report, top of the page, that sentence I keep coming back to, holding commercial people to their bargains. Because I suppose one way of reading that, which I think is what my lady is suggesting, is, well, it just means once you made the bargain, there's a public interest in holding them to it. And then but then of course it would be circular, it would apply in every case. And every time you enter into the contract, the vindication for enforcing the contract is that you've entered into the contract. That's what it means. So it just becomes, it would cover every case. So my submission is they can't mean that. They don't mean that. It's something more specific, which is that it would have been legitimate on the facts of this case for Cabra, who know after all that the club had already taken a different position, supporting the council. Then they, forgive the phrase, get into bed with Cabra for a lot of money. What Cabra understandably don't want is for them to go back on that again. So as it were, on the facts of the case, it's not the public interest in maintaining the contract is the public interest in maintaining contract, whatever they may be, because otherwise this whole exercise becomes completely circular. Because by definition we're talking about contract. It's something more specific than that, which is to do with the facts of the case.
But the question might be asked, if you come to the middle of, or a third of the way down page 334 of the bundle, page 297 of the report, the court will consider the facts of each case. But whereas here a commercial agreement relating to land has been entered into between parties at arm's length, and one party agrees in return for a very substantial payment to support the other party's applications for planning permission, we can see no rule of public policy which renders such an agreement illegal or unenforceable.
Well, my lord,
Sorry, the question is this. How can it be submitted, if you do submit, that that is not the present situation?
because my lord, in my submission, what's being said there is something more specific about the facts of the case. That's why they say immediately before that sentence and immediately after it, well, almost immediately after it, they say before the sentence, they say the court will consider the facts of each case, and then halfway down the paragraph, we are satisfied on the facts of this case. So they're going out of their way to emphasise that they're not making a wider conclusion.
Yeah, but I read the sentence, the second sentence, which did seem to encapsulate a general principle.
Well, my lord,
Is that not right?
in my submission it doesn't. It's a comment on the facts of the case. And again, if I'm wrong about that, it proves too much. Think about what it shows. Because I just come back to the question, and the court didn't decide. It went out of the way to say it wasn't deciding anything more than the facts of the case. Take the case where there's no property acquisition at all, but where the developer simply says to a potential objector, you've got a public interest, you've got a public interest objection to this proposal, you've got some relevant information about the environment. Here's £20,000, please keep it to yourself. That can't be, in my submission, that can't be right. And it would run up pretty squarely against what the Supreme Court of Ireland said in Tasker about the importance of public involvement and the need, and the public being the repository of relevant information which needs to be considered in the public interest.
But here is a member, here for the sake of argument, is a member of the public conscious of their objections, whatever they may be, to the proposal, taking the view that it is in their interests, or not against their interests, to enter into such an arrangement with the developer. One of the conditions of which is that they will not pursue their objections.
Yeah.
Now, why is that contrary? Why is that contrary to public policy?
Well, it depends to an extent what the nature of the objection is. So,
Well,
I mean, we're going to come on to Dr.
Right, well,
Jimson.
maybe I'm taking us too far down.
No. I'm entirely. But I'm not trying to back the question
But I
away.
think we're close to the heart of the case.
I think we are. I will come to deal with Dr. Jimson in somewhat more detail, but just take him in outline, or someone like him. So he's got a property right. He's the guardian of the property as a trustee. Maybe all that's sought is for someone to get a way leave to go over his land. On that issue, he's got no problem. He wants to compromise that. He'd be perfectly, other things being equal, perfectly happy to compromise that property. But as my lord knows, a part of the way compulsory purchase is supposed to work is that those who seek compulsory purchase rights are supposed to try and enter into voluntary agreements, and supposed to do so in good faith. But in a case, but what Dr. Dingemans, in addition to having that property right, that possibly quite narrow property right, has some very wide and principled objections to the scheme as a whole, which have got nothing to do with the property question. So, obviously, we know that Dr. Jimson didn't take the payment. Others may have done. But there may have been other people like Dr. Jimson who weren't quite as principled about it in the end. We don't know. But there could have been. So the vice of the clause that we're dealing with is that they are prevented from maintaining those wider public interest objections. And so the public interest in seeing all of the relevant information come forwards is defeated. So the vice is that the decision maker, examining authority, Secretary of State in this case, doesn't get to take their decision on a fully informed basis, because the tendency of the contracts which have been entered into with the developers, with the affected persons, is not simply to prevent them maintaining their narrow objection, which is met by the payment of money to them, but it is also to prevent them from maintaining their wider objection, which has got nothing to do with the payment of money to them, and which is not met by the payment of money to them.
Can I just test that by this question?
Yes.
If the promoter of this particular order
Yeah.
had owned all the land themselves,
Yeah.
they would hardly have objected to the scheme because they wouldn't have been applying for permission if they were objecting to it.
If the promoter, i.e. SBR, yes.
Yes,
That
had
was-
owned
that's
all
right.
this land, so they didn't have to make any of the
That's right,
agreements.
yeah.
The public would still have had the same rights as they did under the agreements as made with the option agreement. They were effectively taking ownership of the land for those purposes. And yet no one would have said, if they had before this owned all the land, oh, well, this is not a fair planning inquiry
Yes.
because you own the land and you're not going to object. So that I'm just seeing
I
where
see what you
the
mean.
public policy
Yeah.
objection is.
Yes.
Otherwise, you would then be saying, well, if you own the land and you're promoting the bill, then it's contrary to public policy because you're hardly going to object to yourself.
Yes, I see what you mean. It's, I'm not laughing at the point, but it's quite a...
Well, sorry, it's just something that worried
No,
me.
it's
Yes.
entirely just a question. I'm sorry, I'm just thinking through my answer, forgive me. I mean, I think it must be a feature of any scheme like this, that if the developer themselves takes a view they want to develop, and they'll, what they do about those sorts of things is, I mean, it's a matter of their own conscience. It's just an inevitable feature of the scheme. Presumably, if they, in good faith, take the view that, all in all, I mean, I suppose we have to imagine a developer who thinks, I've got a development, it will make me lots of money, but I know it's going to be a disaster for the local community, and I don't care.
And there are those people.
And presumably there are those people, yeah, I mean, I can see that. Sorry, I'm being whispered at, so I'm not being whispered, I think. Yeah, I mean, I can see that. I don't know how any scheme would deal with that particular issue other than by saying, well, we have to rely on other members of the public. If there is a damage to the public interest in that sense, create more traffic. That's why you allow interested parties, affect neighbours, and so forth to be consulted on it. And I can see the logical point that my lord makes. But I just don't see how any scheme could deal with that, because it's in the nature of many people that they act self-interestedly, as it were. But I don't accept that rather, I want to say extreme, because I take the point it might happen quite a lot, but that rather specific problem undermines the basic submission that I make, which is that in a scheme which C and Tasker relies upon the public to provide relevant information to ensure that the public interest is vindicated, you have to that basic aim, the Antasker aim, as it were, is defeated if it's permissible for those very people who would bring full relevant information just to be paid off. Not to be paid off, as I say, in a way that meets the problem, because that's different, I accept that. But just to be paid off. And again, subject to the Fulham Club case, I respectfully suggest that proposition oughtn't to be surprising, oughtn't to be startling. On the contrary, it's a position we would all accept as lawyers in almost any other parallel kind of process, court process, public inquiry process.
If this is a tedious question and maybe,
No.
well, you haven't heard it yet. Is there a particular passage in Fulham Football Club which you say sustains that proposition. It may be that you've already
Well, I think
answered
the
it.
critical passage is what I'm sure that I'm pretty sure I've taken you to the critical passages. I mean,
Yeah.
you've seen there's some earlier sections, bits of this
But
section.
is there a
I think the
particular?
passage that I would point to,
Yeah.
and I have pointed to it, so forgive me, is the passage which starts, it's the final paragraph on 333,
Yeah.
going over the page.
Final paragraph on 333.
Yeah. What's important about that passage is that it's absolutely accepting the applicability. There's two points. It's accepting the applicability of this kind of principle, this kind of concern, to planning just as much to any other context, public inquiry, whatever. And it is explaining the test that is to be applied. Namely, is there a relevant, is any interference with the administration of justice justified by a countervailing public policy consideration? May I just make this point? I'm just coming back to my lady's question, thinking on my feet as it were. But one reason why the court can't be saying the public interest is just seeing contracts vindicated is that would apply not only in all, if that's the right way to think about it, in all planning cases, would equally apply to any other public inquiry context. I've made a contract saying I won't give evidence at the COVID inquiry. That's enforceable because there's a public interest in holding me to my bargain. I suggest that can't be the position, but equally, why should it be any different in the planning context? And now I'm conscious this is a decision of the Court of Appeal, so it's binding on you for what it decides. But I respectfully say you shouldn't read it any more widely than it. I think I am entitled to say you shouldn't read it any more widely than it needs to be read to explain the decision in the case, especially given the repeated emphasis on the facts of the case.
Well, you are submitting implicitly, maybe now explicitly, that these arrangements, the heads of terms and the agreement themselves, interferes with the proper.
Yes, I am. I absolutely am.
And
I'm making that submission.
That's the basic submission.
That is the heart. I mean, in my respectful submission, when we come to the complaint that C's made, we'll see that's absolutely the heart of their complaint. That's the complaint they actually made.
Right, so that is the proposition ultimately on the facts of this
That's
case.
the proposition. On the case. And again, I think in light of Fulham, I can see that it might have been appropriate it might have been legitimate. We don't need to look at this. It might have been legitimate for SPR to say, look, in this particular case, in relation to this particular landowner, we think we need the additional assurance of a clause like this for the kinds of reasons you saw in Fulham, that they're actually, they're messing around or they're playing a very commercial game about what objections they will and won't make and so forth. They're using their objections as a bargaining chip. I don't know. We don't need to decide exactly what it is. What they can't do, in their submission, what is on any view problematic, is for them to adopt a blanket approach. We'll come to questions about whether they were in fact flexible in due course, but to adopt a blanket approach, which is to say to landowners, here's the deal. In return for compromising your property right and making an appropriate payment relating to that, we want, in addition, you to sign up not to make any other kinds of objections at all. Because that must have the effect on those landowners who may be, as I say, perfectly willing to compromise their property right, subject to whether the thing goes ahead at all, in a position where they have no choice. Effectively, it's we don't compromise at all, and we have to take our chances on the compulsory purchase down the line. or we give up all our wider objections. As I say, Dr. Jimson's will see the case in point, because he had all sorts of wider objections, which had nothing to do with the property, or certainly not much to do. My lady, I'm conscious you had the question about, well, where do I get the limit relating to the property right? Why is it about, why does it have to be relating to the land? And I sort of slightly dodged the question in a sense by saying, well, actually my baseline principle is the one in 296, 297 of the judgment. Let me just come back to it briefly. I mean, I think the best answer I can give you is the further away you get from the property right into the field of a general planning objection, the less and less likely it's going to be that you can find a justification for restricting the right, the ability to object. So it may be, so it's a striking feature of Fulham, I submit, that it is the property in question, the property to which the planning application relates, is the entirety of the property for redevelopment. And indeed, as I understand it, the facts at least, they're going to vacate the site.
It does raise the spectre of commercial uncertainty, because you say, well, it's a question of fact and degree on the clause in question, whether on the facts of the particular case you're stifling objections that are not sufficiently connected with the property right.
Well, that's why
that was a real recipe for disaster when it came to trying to
well, that's why.
the contract.
So I in terms of whether ultimately I think I'm not. It's not my primary case that the relevant restrictions must relate to the property right. My primary case is there's got to be a justification. And in my submission, if developers in these situations take this approach, then the degree of commercial uncertainty will not be that great. So the approach that I would suggest they need to take is they oughtn't to enter into these kind of agreements as a matter of course. If they've got a developer, sorry, not a developer, they're the developer, forgive me. If they've got a landowner about who they have concerns as to their ability to, for example, change their production from time to time, then it may be legitimate on the facts of the case to enter into, to seek to enter a clause of this kind in addition to whatever other standard clauses you have. But it does have to be justified on the particular case. And if that approach is adopted, and you've got a developer who, you've got a landowner who is going to be at the more commercial end of things, on advice is willing to accept such a clause, then it's going to be very difficult for them to say that the public interest, which the court talks about at the top of page 297, is not applicable. But what shouldn't happen, what happened in this case, which is that as a matter of course, that's the arrangement that is offered. That's the problem.
Right. All right. So let's just draw breath.
Tony.
One thing I did just want to ask you, it's really just for the reference, the sake of the reference. Where does the judge deal with that?
So he does it in
the submissions you've
done
just
it
made.
in more than one place.
Yeah.
I've got two that I've kind of made a note of. I don't absolutely say there aren't any more, but I think the two principal places. Sorry, let me just find the right one. Yeah. So core bundle obviously, and tab 12.
Tab 12.
And the judge deals with it, and you're going to read this, it's going to prompt a question about what was said below, so I'll just flag it up. I know that question's coming. Page CB 147, paras 87 to 88. But then he returns to it further on mean, the court may want to read that, I'll just find you the other reference, yes.
Well, it's a passage that I think we've all read. There he's referring to Fulham Football Club. He's also referring to other authorities, including Taylor and Chichester and Midhurst Railway Company, and Bilston and Wolverhampton Corporation. But yes, so he returns to this where?
So he returns to it, sorry. So sorry, it's buried in my notes somewhere and I wasn't anticipating to put that one.
Well, if it's not coming to hand, don't worry. Perhaps
Well, I'll come back. I'll get you.
could you come back to it? Because I think just for the sake of good order, we need to know where he dealt with these matters
Yeah.
specifically. The submissions you've just been making.
Yes. I mean, I don't know. Let me just say this now because I suspect we'll make this point if I don't. I don't know exactly how this point was put to the judge.
Well, do you know that it was?
Well, the point that I have been making to you is what I do know is this. The point that I have been making to you is, as we'll see shortly, is right at the heart of the complaint that my part was making. So see that it's quite an important point. Secondly, my lord, it's also right at the heart of the grounds for appeal. To this court on which permission was granted.
All right. Well, if you want to take us to other passages.
And sorry, so another point that it's made. Well, so sorry, I picked up one of the other references which have. So it's 164.
Yeah.
What this turns out.
164.
Sorry, paragraph 164, which as
Yeah.
it happens is on CB 165. I should say.
Yeah. Let's just remind ourselves of that. He deals there with the COVID inquiry.
COVID inquiry point.
Point.
So it's plain, at least. So I don't quite know how the point's been put. I just have to be honest about that. But it's plain that this issue is being raised.
146, he summarises the chilling effect submission.
Yes. Yes. Yes.
Lord, if it helps in terms of references, on core bundle page 133, paragraph 31, there is a recording of Melanson Wolf's concession that he did not argue that either the heads of terms or the option agreements were unlawful or contrary to public policy. Then reference, I think, has been made to paragraphs 87 to 89, where the same point is recorded and expanded upon. And then at page 155, paragraph 122, the judge returns to the same point as part of the reasoning. And that reflects, as the judge's judgment makes clear, an express concession. These were not contrary to public policy.
So what was
the
the
other-
last one that you gave us, please?
Paragraph 122 on
122, thank you.
page 155.
Thank you.
Thank you. Thank you, Mr. Philpott.
So can I just, while we're on this exercise, the grounds of appeal, which are tab 2 of the core bundle, these concentrate on the grounds of
Yeah.
permission was granted,
Right.
do plainly put this point in issue.
Second.
CB 17, I should have said. So 1A, failing to correctly address or construe the heads of terms and including the obligations when occupied, silence or related entry acquisition of property rights.
That's a construction point, not a
It is,
legality
but it
point.
goes, yeah, it is. Holding the except that C, holding the sentence payments were linked to and justified by a statutory code or compulsory acquisition or purchase or in accordance with the professional duties of land agent. So that's a submission that the payments were not justified. And I'm so sorry, I'm trying to link that up with the reference in the first paragraph, the first of those, to buying silence and related to the acquisition of property right, is picking up on something said by the judge, and I'm so sorry, I've put a note somewhere of the paragraph reference.
So where is the criticism of the judge on this point?
Sorry, let me just. I think if I if I try and search around frantically, I'm going to.
Well, don't do that. I mean, but we've asked. It's I hope a fair question to ask you at this point.
No, it's a fair question.
So
But there's
by
a
all means,
reference in the judgment that I particularly want to find out.
surely yes. Well, by all means, come back to that later if you'd like to. Just taking stock then. Where are we?
So, my lord, the issue which I submit lies at the heart. Is the one that I have been presenting submissions on.
Yeah. I mean, is the point? I mean, I appreciate you've got other things you want to say,
Yeah, sure.
but is the point you've been developing in largely in exchanges with us really the central proposition?
I said, as I see it, it's certainly the central legal issue that you need to deal with. Yeah.
Right.
Because if we just think it through, if I'm right about this point, and in a sense this is a helpful link up, I think. If I'm right about this point, then my client's complaint either raises a serious issue or frankly a correct point about the tendency of these contracts to suppress evidence. And then what remains, now that's not an error of law by the Secretary of State per se because it's the conduct of the SPR. But what remains is to think through the implications of that, what the Secretary of State needed to do or didn't need to do, what the Secretary of State actually did or didn't do, and so forth, the kind of factual questions.
Yeah. So is that where we go next?
Well, it is, and I think the sensible point to go to next is to deal with one. I mean, it's a more factual question, but it is also about the contracts. So let me deal with that now. So this is about the point about the heads of terms, because what I've focused on so far is, of course, the non-objection clause as it appears in the options agreements. And what the point that's made against me is that that's the option agreement, not the heads of terms. Options agreements aren't signed, or for the most part aren't signed, while most of this process is going on. In the heads of terms, there is we'll see it, there's a somewhat similar term, but it says that's not binding, so where's the problem, effectively, summarising.
Yes, I mean the sequence of events is said by the other side to be important,
Yes.
significant, and the submission is made that the heads of terms were not binding.
Yes.
Were not binding in a relevant way at the relevant time.
Yes.
At least.
So what I'd like to do to deal with that, and it is to show you the heads of terms and how they worked, to show you how we meet that. But I should perhaps say, I'll make my submissions to you at this stage, but that's without prejudice to my position, which is that these are matters to an extent which were for the Secretary of State to address. So, in other words, if the Secretary of State, what the Secretary of State should have done is make a decision about whether actually this kind of contractual arrangement was legit, this kind of non-objection clause was in principle acceptable. And then the Secretary of State, not the court, should have done the exercise of thinking through what the implications of that are on that premise. That's effectively the case. And I say, and I'll come to it, we didn't do that.
Why
But
would the
I need to say
Secretary of
something
State-
about why the heads of terms not binding point is not, as it were, a knockout to my argument. Sorry, Lily.
Well, I'm just thinking aloud.
Yeah.
Why should the Secretary of State ask us question number 1 whether a clause of this type is acceptable or not, if the clause isn't binding anyway?
Well, that's part of the answer. I mean,
It's putting the cart pretty firmly before the
Well,
horse.
if the position is that there's a complete answer, because, for example, the heads of terms aren't binding,
Yeah.
then possibly you refuse relief. Possibly the Secretary of State, because under section 31, whichever the subsection is now, highly likely. There's lots of them.
Well, section 31 2A,
2A, I think. It is.
highly likely that the outcome
Highly
for
likely.
the
So either you refuse
claimant.
relief on that basis, or at a prior stage, it said, well, the Secretary of State was entitled to be satisfied that there was just no problem here, and or was satisfied that there was just no problem here, and therefore, there's no problem, there's no illegality, etc. Either there's no illegality or you refuse relief. So
All I was
the
doing
exercise
really, Mr. Bewley, was querying the order in which the Secretary of State is obliged to look at the matter,
Well-
because you said the first thing was to decide whether in principle a clause of this kind is acceptable. And it just seemed to me that was probably the second step if it was a binding clause.
Well, I mean, to some extent, it may be for the Secretary of State to decide. I mean, one of the things I need to deal with is what the Secretary of State actually did do in response to the complaint and whether that was satisfactory. In a sense, I'm getting ahead of myself. Can I just show you why, on the face of it, and these are effectively the submissions that C's made to the Secretary of State as well, the heads of terms point is not an answer or not a knockout answer or not a reason not to investigate further or whatever it is. Why that's so, that's the submission I want to come on to. So the heads of terms then are at tab 2 of the supplementary bundle. And this is obviously a specific case, and you can see, I think on SB 17 I should have said, this is the one with Dr. Jimson's mother, which is the one that with him effectively, which is the one he had access to.
So this is Dr. Jimson's mother.
So you see that Grant or Elspeth.
Yes.
Jimson.
Yeah.
SB 17. My learned friends will emphasise, and so let me show you. It says heads of terms, and it immediately says without prejudice, confidential, subject to planning and contract.
Sorry, page 17. I was in divider 17.
I'm so sorry.
No, my fault. Thank you.
Yes, it's divided 2, but I suspect you found it. And then, so I have to show you that. The other point, though, to make about this is it's quite instructive to look at the date. So date and version, 13th of January 2020. I'll say why that matters in a moment. But if we then go over the page, SB 18, the way this works is that it provides for, you can see in the middle of the page, incentive payments. And there's a what's called a head of terms payment, £2,500, and I think what is effectively an additional bit of heads of terms payment, which is £2.50 per square metre, which in this case was £1,000. Then there's an option agreement incentive, and there's an option agreement rate as well. Which again is 1,000. I think it's the same calculation. So all in all, as I understand it, that comes to £6,000. And we're told what the incentive payment is on SB 19. So probably the facing page if you've got double-sided. So if you've got that 0.7 on that page, bottom, incentive payment, £2,500 heads of terms payment for signing heads of terms by the 27th of January, payable on completion of the option agreement, together with the heads of terms agreement rate, being 2, etc. For the avoidance of doubt, this payment cannot be claimed after 27th of January 2020. And then it said a further option agreement incentive for agreeing the option agreement, etc. And I don't think I need to read it out. And then there's again, point about the date. So what that's making clear is that although you get this heads of terms incentive and you get the option incentive, in fact neither of them is payable on the signing of the heads of terms. They're both payable on the signing of the subsequent option agreement. And so effectively what this is doing, legally binding or not, is putting a signatory on a track to signing the relevant option agreement. This is where the dates come in. As I've said, the date of this agreement is the 13th of January 2020. And the date that it is envisaged that this person must sign by is the 27th of January, only 14 days later. So whatever happens in practice, the expectation of the heads of terms agreement is that you move rapidly from heads of terms to option agreement. And we know that that's not in fact what happens. Lots of people are signed up to heads of terms and then the option agreements don't get signed at all until the very end of the process at all. But undoubtedly the signatory is working on the understanding that they're going to move pretty rapidly, or very rapidly frankly, from heads of terms they have signed to fully enforceable option agreement. And then the other point that goes with that is if we then look at SPV 29, we find the relevant clause, or 31.
So you're focusing on the words for the avoidance of doubt. This payment cannot be claimed after the 27th.
Well, I'm really just focusing on the date sequence actually. I mean, yes, that's what it says, yeah.
Yeah, but there may have been, we don't know, do we, or do we know? There may have been other correspondence around.
No, exactly. It may well be. It may well be. Indeed, I anticipate it probably would, but I don't know. That what would in practice happen is that when things turn out to take longer, there's a side arrangement or an expectation or a.
And is this a standard
Again,
clause?
they're not my contracts, so I don't know. But that's our understanding. This is how they work.
What does Dr. Jimson say about this actually?
Whether he specifically said something about the date, I'm not sure. I'd have to come back to you on that.
We've got a witness statement from him, haven't we?
He certainly. Can I dig up chapter and verse perhaps over lunch?
Of course, yes.
He certainly
It's on
signs,
page 399.
Yes, great. Thank you.
But anyway, if you want to come back to it.
I'll perhaps come back. I'll just find the page that you're correct. Thank you.
Yeah,
Oh, sorry, that's a statement. Yes, I see. Yeah.
this is witness statement, yeah.
Yeah, sure. I'm not sure that he said something specifically about the date, but certainly my understanding is that he's anticipating in fact the payment will be made to him, although the time has passed, but effectively in 2021.
Well, once the time passes, unless there's some other arrangement put in place, then
Yes.
the time has passed.
So it tends to look as though in practice, and again, I don't know what SPR's general practice would be, only if Phil can answer that if anyone here. But the only point I'm making about the dates, or the point that I am seeking to make about the dates, is that a person who signs up to these heads of terms is thereby put on a track whereby their initial expectation is going to be they're going to move pretty quickly, very quickly, from heads of terms which are, may not be binding to option agreement, which definitely is binding. And just to complete that picture, sorry, the page I wanted to take you to, let me just take you to now, SB 29.
Yeah.
Planning matters. The grantor will not object to the developer's application for development consent nor any other planning application associated with the projects. So the affected person who signs these heads of terms is signing up to the principle of non-objection. And again, that's just as general. It's not as detailed, but it's just as general as the one we've been looking at. You don't object to the application for any of the applications for development consent on any grounds not qualified. So signing up to that principle, and they're doing so in the expectation that they will move rapidly to a situation where they are legally bound. And that's why the point about these not being legally binding is not a critical, can't be an answer. Because if you think about the practical effect on someone who signs up to the heads of terms, and I understand it, most people did sign up to heads of terms. Then the effect is bound to be to stymie their support of an objection, their pursuit of an objection. I mean,
Well,
just
I
think
can
about
see-
it in
I can
practice.
see the argument that for some people who are not necessarily well versed as lawyers, they can see that they bought into the principle of not objecting, however fast or slow you're actually getting into the option agreement, and therefore it might tend to a layperson to dissuade them from objecting.
Yeah.
I think that's about as far as you can push it, particularly when Dr. Jimson himself said, I had no idea whatsoever that I was inhibited from saying anything about this. And I didn't understand the clause to inhibit me. Now, Dr. Jimson's obviously a very intelligent and articulate gentleman, and he obviously understands the legal position perfectly. But I can well see that you say that somebody who looks at this and buys into it might well be dissuaded.
Yeah. Well, Milady, so that's one point, as it were, that some people will be dissuaded for the reason you give, that they don't understand it's not legally binding. In my submission, there's another point which is important. Dr. Jimson isn't the best example of this, actually, because he doesn't really notice. He doesn't seem to notice this clause.
Dr. Jimson and his mother had the opportunity of taking legal advice from their solicitor, whose name appears in the document.
They did, yeah. But there's another point, which is the legal advice doesn't answer, as it were, which is this. Suppose you're an objector and you've got your compulsory purchase objection. Well, you may very well maintain that objection for the time being. Let's suppose you perfectly understand the legal position, precisely because it's a bargaining chip in terms of what follows next. But suppose you're someone who, apart from that or in addition to that, is thinking about making an objection on a wider basis. Now that wider basis for making the objection can only serve a purpose if it's pursued to the end of the process. It's no good making it and then withdrawing it once you sign your, you might as well not have made it. And your motivation, once you've signed these heads of terms, your motivation for maintaining that objection is reduced to zero. What's the point? Why go to the trouble? Once you're on a track of, I'll withdraw all my planning objections, of course, even if I'm speaking, I'm allowed to make them now. And, oh, well, I suppose I could stick in my, I'm not strictly bound not to make it as yet. I'm not strictly bound by this clause as yet because I haven't signed the option agreement. But I'm signed up to the principle. I'm being told I'll be paid, as it may be, £5,000 or whatever it is, once I do so. And at that point, I have to withdraw the objection. That person has absolutely no motive to make the objection or to pursue it. And that's even if they have a perfectly good understanding of the legal position. Because they know it won't go anywhere. You might well pursue, as I say, the more narrow property-based objection, precisely because that's what this is all about, and you want to do so. But your wider planning objection is not necessary to get this agreement. There's nothing to be gained by pursuing it, and so therefore you're back. I expect to say, I mean, I don't have to put it this high, but you're bound to withdraw it or not pursue it or not develop it at whatever stage you're at. And certainly there's a real risk, a serious risk. That's exactly what you do. in my submission, that's the critical point about why saying these aren't legally binding, which frankly would not have been apparent to everybody, there it is not an answer. The whole, this is, I mean, C's make kind of detailed submissions about this, which I'll show you. But the heart of it is, it's a system. It's a system. I mean, whether it's intended as such, I don't know. It's a system. You put the person on a track which prevents them from maintaining a wider planning objection. Makes it totally pointless to do so. Whether they're legally bound or not, therefore, is not the key point. They've signed up to the principle, they know they're going to be legally bound, and they know if they don't stick with it, they're not going to get the payment. Now, to a degree, and this is ties into something I said earlier, these are questions of fact and degree and judgment. They're precisely, we say, the kinds of points the Secretary of State needed to think about. And as I will show you, C's made very detailed representations about it. Continually making these points.
And where does that fit in with a finding that, okay, I understand that you might have withdrawn an objection, but it was completely nonsense in planning terms, and he might have withdrawn an objection, that was also nonsense. And actually, I've looked at all the objections that have been made and all the proposals in support, and I find that I have enough to determine this fairly.
I'm probably being dead. I'm not following. I'm sure that.
So
I here is it.
So if the person who is incentivised, as you put it,
yes,
to withdraw their objections,
yes,
does withdraw their objections,
yes,
if in fact they were nonsense planning objections in the first place, and the Secretary of State considers that there is enough information to decide this fairly, what's wrong with that?
we don't know what objections they would have made. The Secretary of State can't know what. I mean, again, I'll come back to that. We're going to circle back to that when we look at the Secretary of State's decision and how the Secretary of State did.
Do we have any
The
evidence?
short answer is you can't know what objections they would have
No,
made.
but we don't have any evidence about what those
No,
objections.
we don't. So that, in a sense, I mean, let's for reasons which I hope will be obvious, the ability of my client to get that evidence is very constrained. Indeed, it's constrained by the agreements because I haven't made so much of confidentiality clause, but you've got the point that there's also a confidentiality clause. So C's even being incredibly proactive about it, I submit it shouldn't have to be to deal with this kind of problem, can't get that. So it can't go to landowners and say, you sign the agreement and say, tell us what you would have said and we'll put it in, because those landowners are going to, I would have thought at that stage they would be in breach of their agreements, and they're certainly going to fear they are and fear they're going to lose their payment.
So what should the Secretary of State have done?
Well, we're getting ahead of ourselves, but
I'm
that's
sorry.
Okay. No, that's all right.
It's very tempting to ask that now.
No, I can see. I mean, all these questions have to be they're perfectly sensible
I mean,
questions.
for example, and this does relate to the recent examples, should the Secretary of State have inquired the nature of the...
Yes, well, that's one thing he could have done. Yes, is the answer.
But should have done?
So, should have done. Yes, or should have done. Well, I mean, again, to some extent, we have to look at what he did, and then I can make my submissions. But to give you the point, the answer at this stage, I mean, C's went so far as to say that the problems created by all this were irremediable, and therefore the Secretary of State. That's the point made by the judge and made against me. Therefore, the Secretary of State had no choice but to refuse on that basis alone. But there are obviously things that the Secretary of State could have done which would have fallen short of that. Whether they would have been adequate can only be judged if they had done them.
Is the logic of this...
But for sorry.
Well, maybe I've got this wrong. Is the logic of this that the Secretary of State was put in a bind, in effect, because you say he should have inquired as to the nature of the objections?
Yes.
But the putative or potential objectors were constrained by their own agreement not to tell him. So he was thus left in a position of not being able to grant development consent and would have to refuse it ultimately because of the agreement not to disclose an objection.
So, my lord,
Is that how it
one of
goes?
the, well, so my answer is this. That's one of the reasons why I say that what the Secretary of State did really need to do is to reach a decision about the basic point that I've been making to you already. Are these or are these not contrary to public policy or legitimate, such as to have a tendency to distort?
But my question,
Because,
my
well,
question to help you,
Yeah.
my question allows the proposition that you've been advancing.
No, I follow. Forget. I don't want to cut you off, but I am
well,
trying to get to
just to emphasise what I'm putting.
But you see, the point is this: if the Secretary of State does that, and decide, first of all, the Secretary of State might have decided, presumably, we would say wrongly, but we might have said, no, these contracts are fine. Well, then that's his decision. No need to go any further. There's also a clear target for judicial review. That would be the issue on the claim. Well, the Secretary of State might have effectively accepted what we're saying. Might have accepted that actually these sorts of arrangements are not acceptable from the Secretary of State's perspective. Well, the Secretary of State could then do a range of things, but one thing the Secretary of State could do, and I say the Secretary of State, really it should have been the examining authority, much better if it's done at that stage. So the Secretary of State, to some extent, is in a bind because he gets nothing for the examining. That's not helpful. But that can't be a point against me as a player. But in one of them deals with it and says, look, says to SPR, look, we've reached a conclusion on this. We've issued a ruling or a decision on whatever it is. We don't think it's acceptable for you to proceed in this way. And, you put it different ways, it's likely to be a material consideration against you, or more strongly, we are unlikely to be able to be satisfied that we can recommend approval unless you sort it out, SPR. Now, SPR at that point is perfectly at liberty to do all sorts of things. It can go back to the landowners and it can say, we want to make clear, as it may be, we're not intending to cut you off from making wider objections, or we're willing to vary the clauses in all cases. It all sort of depends what stage you've reached in terms of heads of terms and so forth, isn't it? But, and therefore, if you've got any of those sorts of wider objections, you're perfectly liberty to bring them forward. Now, query whether that would be enough, because I suspect my client would have said, okay, you should have, it's too late, the kind of horse has left the stable or whatever it is, that the process has already been too corrupted. And the Secretary of State would have had to think about whether that was right or not. And if the Secretary of State then reached reasoned conclusions on that question, having taken those steps, the Secretary of State would be it would be a different claim if it got to court, put it like that. But the question of is there anything that can be done? I mean, there's a very clear example of what can be done, and that's why I started. I'm sorry, I know it was a little bit roundabout by saying that that's one of the reasons I'm saying that actually really the Secretary of State should have dealt with the in-principle complaint first, because by doing so, which is what Seas was inviting him to do, by doing so, the Secretary of State, examining authority, whatever, can then justify a course which would seek to remedy the problem. Now, I suspect it will be said against me that that specific way of dealing with it wasn't put to the Secretary of State by Seas, and I think that's probably right. But it's not the logic of my case that the Secretary of State could do nothing but refuse so far, subject to ruling against us on the principal complaint. There's plenty of things the Secretary of State could do. Also, the Secretary of State could have required some independent examinations of matters relating to the land in question, for example. It might be harder to do, but it's not done. And obviously, the earlier all of these things are resolved, the more likely you're going to solve the problem. That's why, see, if you get to the stage where the examining authority has not dealt with it, and the Secretary of State has to decide what to do, well, the Secretary of State is in a bit of a bind. Not because he completely prevented from doing anything, because I think he's entitled to require the inquiry to be reopened. I'll be corrected if I've got that wrong. But he's in a more difficult position than he would have been if the examining authority had dealt with the point. But with respect, there's nothing unusual about that. That's always the position that the Secretary of State will find himself in if the examining authority doesn't deal with an issue properly. We say, as I shall seek to show you, the examining authority didn't deal with it properly. It sort of dropped the ball effectively. It just ignored the issue. Having said that it would deal with it, we'll get into the detail. I think I was responding to my Lord's question.
You were.
I think I probably
You were.
talked myself out.
That's what you were doing, and you did.
Yes. The next task is to look at, to make good a point that I've been making to you. We didn't necessarily spend ages on it, but look at what the C's complaint actually was. I'm looking at the time.
Right. Well, do you want to start on that at 2 o'clock?
Fine.
We said at the beginning we had a hiatus, of course, for the live stream to be arranged. We said we'd just consider where we were
Yes.
at this point. Of course, we've asked you a lot of questions.
Yes.
As in the nature of things. How much longer do you think you need to develop your?
Well, I'm sure I'm going to finish today. I'm sure I'm going to finish.
Oh yes.
Yes. I'm relatively. There's a strong hint there.
Well, I mean,
I'm going to finish. I mean, I think I've probably got an hour or so.
An hour.
So I suspect we're not going. Bearing in mind, I've got 2 opponents, so.
right, well,
But unless they can say, I can deal with all of Mr. Bewley's rubbish in 2 minutes, I suspect we're going to be going.
well, I'm sure that's not going to be said. Mr. Westman-Smith, Mr. Philpott, if Mr. Bewley takes another hour or so, and I'm not minded to impose a hard deadline, given that the time estimate was 2 days, how much time do you think you would need?
My lord, I had in mind that it would probably take me 2 hours to go through my submissions, depending on the level of interaction.
Your lordship will have appreciated our cases are very closely aligned. I will therefore not repeat anything. I would anticipate up to an hour, but hopefully considerably less.
So we've got 4 hours altogether, roughly speaking, puts us into tomorrow, but not beyond the midday adjournment tomorrow. And I think that should be our realistic aim, because in the nature of things, argument has helped us to get clear in our minds the most important parts of the argument put forward. And that's been most useful this morning. Thank you very much. So we'll start again at 2 o'clock.
Court rise.